Okay, this is a lecture for POL 325, or Civil Rights course, and we've been talking about gender discrimination. And in talking about gender discrimination, we've done a lot of things. We've talked about the 4 legal areas of gender discrimination, and we've given you, I think it was something like 15 different cases that are significant legal cases dealing with this whole issue of gender discrimination. And based upon my notes, we're up to number 11. And number 11 is the case of Michael M. versus Superior Court of Sonoma. And this is a 1981 case. It was decided by a 5-4 decision. And again, it's trying to get at this whole idea of what is gender discrimination and how do you approach gender discrimination in a way that makes it equitable for both men and women. And we've talked a little bit about that in some of these prior cases like Orr versus Orr, where we talked about how alimony should be issued in a way that could go to a man or a woman based upon need, and that sex should not be a proxy for need. Well, let's talk about a little different approach that was used by the courts here, where they came to a different conclusion. So in Orr versus Orr, they're saying there is no compelling reason for these gender discrimination. But in Michael M. versus Superior Court of Sonoma, we have a very difficult kind of question. And the question that is addressed by Rehnquist, who writes for the majority here, is, does the state of California's statutory rape law violate the Equal Protection Clause? And the reason they ask that question is because the California statutory rape statute, as many other states did too, held that males alone are criminally liable for this type of act of sexual relationships. And it was applied to a specific case. So in June of 1978, Michael M. was a 17-year-old male, and he approaches a 16-year-old female, Sharon. They go to the park, they go to the park bench, they start kissing. He asks her for sex, she refuses, he hits her, and then she complies. He is then charged with statutory rape because she is underage. Now, the thing to note from his lawyer's perspective is he's underage too. So what they argue is that this statute is unconstitutional. The California Supreme Court held that this statute discriminates on the basis of sex because, as it is written, only males can violate the law. And that there must be prosecution of both minor males and females, or it's a violation of Equal Protection Clause. So it goes to the United States Supreme Court, and they have to grapple with this. So as you can see through this evolution of case law that we've been looking at, any kind of gender distinctions have been held to a higher level of scrutiny, that there has to be some kind of compelling reason for these distinctions. And the United States Supreme Court, in looking at the law and looking at the circumstances, upholds the law. They uphold the California law. So what are the compelling reasons? And one of the things they say, to preface this, is that sexes are not always similarly situated, and that the Constitution does not require that things that are different must be treated as if they were the same. So what they're arguing is inherently there are differences based upon gender, that there are differences between men and women, and that this case deals with some of the most basic differences. They said the justification for this law by the state of California is to prevent illegitimate teen pregnancies. And that's a very important societal interest and objective. And therefore it's entitled to great deference. And the court says that they are satisfied that the state has a strong interest in preventing such pregnancy because it has significant social, medical, psychological, and economic consequences. And that in this case, young men and women are not similarly situated with respect to the problems of sexual intercourse. Why? Well, according to the court, only women can become pregnant and therefore suffer the physical, emotional, and psychological consequences of pregnancy and child rearing. So that criminal sanctions on males, and males only, equalize the deterrent. And not only that, if you don't do that, females would be less likely to report statutory rape if they also would be subject to criminal prosecution. And clearly society has a significant interest in preventing statutory rape. So what is happening in this case, which is very significant, is that the court is saying that not all distinctions based upon gender are by definition unconstitutional and violations of the 14th Amendment. And we're going to see that with some other cases. So when you look at Rossiker versus Goldberg, that's a 1981 case. And it was decided by a 6-3 margin. And in this case, we're dealing with the Selective Service Act, the draft. And the Selective Service Act requires every male citizen between 18 to 26 to register for the draft. So it requires only male citizens to register. And in 1980, the draft was reinstated by President Carter. So it was immediately challenged by Rossiker as being an unconstitutional violation of the Equal Protection Clause. If he had to be drafted, why shouldn't women be drafted, was the argument. And consistent with that article, a federal district court declared that the law was unconstitutional, the Selective Service Act. So the government and the director of the Selective Service appeals to the United States Supreme Court. And Rehnquist again writes a decision, the majority decision in this case. And he again makes the argument that there aren't a lot of differences between men and women that require legal protection or legal distinctions, but there are some. And Rehnquist argues that the exclusion of women from the draft is not a product of traditional female stereotypes, that male-only registration programs are substantially related to the important governmental interest in raising soldiers for combat duty, that this gender classification is not invidious. All right, so in other words, it's not intended to harm women, but rather it realistically reflects the facts that the sexes are not similarly situated in this case. And that men are better suited for participation in the military than women are. Now, as we said, this decision was 1981, and there have been many changes in the military since Rossiter. So women now make up 15 to 20% of U.S. military forces. In 1967, it was only about 2%. And according to new classifications, women qualify for 95% of all military positions. There are some exceptions in regard to special operations and some direct ground combat troops, but otherwise women can do all the same things as men. So the question that some legal scholars have asked, given this change in society, given in this redefinition of gender roles, would the court hold the same way if the draft were reinstituted? And it's an interesting question that we can debate. So, Michael M. and Rossiter are interesting cases because what they do is, while they acknowledge that any law based upon a gender distinction must be closely scrutinized, they come up with two examples of laws that they say are based upon rational gender distinctions that should be upheld. Now, I want to transgress a little bit here. I want to go backwards and talk a little bit about the issues that relate to kind of Michael M. and our history. This whole issue of gender and rape. Gender and rape. And in this context, we will talk about rape, we can talk about date rape, we can talk about spousal rape. These are important issues in terms of violence against women. So let's look at rape historically. Historically, as we've indicated before, women were viewed socially and legally as the property of men. In other words, initially the property of their fathers, and then their husbands. So, original rape laws were seen as a crime against the man. Now, rape is an ancient crime in Anglo-Saxon England, and it was punishable by death. Rape was defined as carnal knowledge, in other words, sexual intercourse, by a man with a woman, not his wife, that was forcible and without consent. So this original legal analysis of rape held the following. Only a man could rape somebody. Rape included only vaginal intercourse. Men could only rape women. Men could not rape their wives. This was considered to be, quote, the marital rape exception. In other words, you can never rape your wife because she's your property. Rape required force. It was defined as a crime of violence. And that has implications that I'll talk about in a minute. And rape had to occur against a woman's will or without her consent. So within this historical context, from the 17th century to the 1970s, the law concentrated on the element of consent in rape cases. Women had to show that there was not consent. And for most of this era, in most of the states, women had to show resistance. And only by showing resistance could they prove that they did not consent. So if there was any submission, while a woman had the power to resist, it would remove an essential element of the crime of rape. No matter how much force was imposed upon her, she had to resist. Now that's very different than other criminal acts. So in other crimes, a person's acceptance of the crime does not constitute consent. For example, robbery. So if you take somebody's property by force or threat of force, it does not require the victim to resist to prove that there was force. And until the 1950s, the amount of resistance required to prove this lack of consent was, quote, the utmost resistance standard. That a woman had to exercise all of her power at their command to physically resist. That absence of mental consent could never be enough. So in other words, if you screamed, even that was not enough. There must be the most vehement, according to case law, I'm going to quote it, the most vehement exercise of every physical means, and it must persist until the offense is consummated. Now, even at this time, though, intercourse with a woman who was incapacitated, either by intoxication, mental deficiency, or insanity, was considered rape, regardless in that context of force or consent. Now, in the 1950s, the courts replaced this standard of what we refer to as the utmost resistance test with a reasonable resistance standard. So it measured resistance by the circumstances, by the amount of resistance that is required by what they refer to as the totality of the circumstances in each individual case. So the Virginia Supreme Court ruled that a woman is not required to resist to the utmost of her physical strength if she can reasonably believe that resistance would be useless and result in serious bodily injury to her. So with this type of changing sentiment, we see during the 1970s and 1980s some major reform. We have the National Violence Against Women survey, and what it shows is that 25% of women said they were raped or physically assaulted. And the magnitude of this result stunned a lot of lawmakers. So many states respond by enacting what are referred to, first of all, as rape shield laws. And rape shield laws prohibited the wholesale exposure of a woman's sexual past. In other words, one of the common tactics used by a lawyer defending someone who was accused of rape was to put the woman on the stand and ask her about every single sexual encounter she ever had in her life. And obviously they were doing this to first embarrass the woman, but also to show, see, this person has loose moral character and really can't be raped. At this point, most states have enacted these rape shield laws, and this approach is no longer used in our court system. They've also modified the requirement, most states, that prohibits prosecution unless women promptly report the rape. And we've seen that with the Me Too movement. Some of the reports are 10, 20 years ago. The third thing that they did in the 70s and 80s is states abolished the marital rape exception. So by 1993, this marital rape exception was excluded in all 50 states. And in regard to the element of consent, states have enacted criminal statutes shifting the emphasis from the victim's failure to resist to the force, to the actual force the rapist used. So if the rapist was using significant force, you could not expect a woman to resist. Now, when you look at current laws, there still are some exceptions and defenses to rape. And in most states, once someone is involved in a sexual act, they can no longer credibly, according to rape statutes, indicate that they're no longer willing. And most state laws say there is no rape by trick or fraud, provided, of course, that there was actual consent to the act. So this was a famous case, actually, out of New York called People versus Evans in 1975. And in this case, Evans would meet airplanes at LaGuardia Airport. And he would go up to women, and he would say he was a psychologist doing a magazine article where he was interviewing people from different states about sociological issues. And he didn't use his real name. And he would take these individuals to bars and to dinner. He would do word association with them. Then he would start telling them how they reminded him of his deceased wife, and obviously he was never married. And he would con them into having sex with him, and then he would tell them, after all that, he really wasn't even a psychologist, this was all a ploy. Well, many of these women filed rape actions, and the courts held that he was not guilty of rape because, as we indicated, you cannot have rape simply by trick or fraud if there is consent. So it's significant to understand the history, the law, and the context of rape when you're looking at some of these cases. The next case we're going to look at is Mississippi University for Women versus Hogan. And this is a decision by the United States Supreme Court that's issued by Justice O'Connor, obviously a woman. And the question in this case is, does a state statute that excludes males from a state nursing educational program violate the Equal Protection Clause? Now, to understand this case, you have to understand a little bit of the history of this institution. Mississippi University for Women was established in 1884, and it was originally called the Mississippi Industrial Institute and College for the Education of White Girls. I'm not even making that up. It then becomes Mississippi University for Women, and it was the oldest state-supported all-female college in the United States. And what happens is Joe Hogan, who is a registered nurse, applies for admission in 1979, and he was denied because of his gender. They said, look, we don't accept males. This is just for women. So he brings this to the federal district court. They deny him relief, and they say the state had a legitimate interest in providing the greatest range of educational opportunities. So within this context, what they're basically asking is what's wrong with men only or women only colleges? And they say nothing. Well, he then appeals to the United States Supreme Court. And the Supreme Court says that a challenge policy that discriminates on the basis of gender must show exceedingly persuasive justification that serves some important governmental interest. And according to the United States Supreme Court, this Mississippi program is repugnant to the 14th Amendment because all it does is have presumptions of the inferiority of women. It makes the assumption that nursing is only for women. So the state has fallen short of establishing any exceedingly pervasive justification needed for gender classification. Well, that leads to this whole question. Could you ever have a male only or female only college? The reason they overturned it here is because they said there's this presumption that because it's dealing with nursing, the presumption is that only women are qualified for that, and therefore it's based upon a sexual stereotype that we don't want to reinforce. Well, that leads us to the case of the United States versus Virginia, decided in 1996. And it was decided by a 7-1 vote. Matter of fact, I think it was Clarence Thomas didn't participate in this case. And the reason why is his son attended VMI, which was the school involved here. So what's going on in this case? Well, there were 15 Virginia public institutions of higher learning, which included an incomparable military college called VMI, the Virginia Military Institute, a highly renowned and prestigious institution. It was founded in 1839. It was the sole single-sex college among Virginia's 15 institutions of higher learning. But it had a very specific mission. Its mission was to produce, quote, citizen soldiers, men prepared for leadership in military service and civilian life. And in 1996, their enrollment consisted of 1,300 men. About 15% of these VMI cadets entered the military. VMI had the largest per-student endowment of any public institution in the United States. It graduated numerous military scholars and generals and commanders. Some of the most significant political leaders in Congress and in our nation, at the state and local level. But it believed in a very Spartan approach to this. They used a physical adversarial method. There was physical and mental discipline, physical rigor, the application of mental stress, the absence of privacy, Spartan barracks, no curtains, no privacy, no private showers, public showers, constant surveillance, what they referred to as rat lines, where they could physically torment and punish you. And the belief was that this very demanding physical, mental, academic approach would produce the best graduates prepared for military life. Well, in 1990, a female high school student sought admission to VMI. Now, why she didn't want to go there, I don't know, but she wanted to. And she was denied because of her gender. After her application, another 300 women applied. And none of them were even responded to. So they are taken to court and sued as a violation of the 14th Amendment. The district court rules for VMI. And they say, yes, we're looking at this from a strict scrutiny perspective, but that this college serves a very important governmental objective, and that its discriminating means are substantially related to that objective, and that education in a single gender environment yields substantial benefits. And you have to look at this as just a different way of educating people. It leads to diversity in Virginia educational institution systems. And the Virginia Court of Appeals disagreed. And they argued it has to do more than just favor one gender. And that there wasn't any comparable woman college that did the same kinds of things. Well, as a result of that decision, Virginia proposes a parallel program for women. And they called it the Virginia Women Institute for Leadership. And it was a 4-year program.